Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal said, I'm Judge Orfinger, and I'm joined on the panel today by Judge Wendy Berger on my right and Judge Ann Melinda Craggs visiting from the 5th Circuit on my left, and we welcome Judge Craggs to the court today. If you have a cell phone or anything else that makes noise, please silence it so that we don't interrupt the parties during their arguments. We have one criminal case and the rest are civil cases. The criminal matter will have 15 minutes per side. The clock is set for 5 minutes for rebuttal, but if you want something other than that, let me know and I'll set the clock. When it starts to flash yellow, that means you're into your rebuttal time. So with that, we'll go ahead and call the first case, LOUIDOR versus State.
Good morning, Your Honors. My name is Mark McCulloch. I represent the appellant, Mr. Luke LOUIDOR. I'm battling a cold this morning, so I apologize if my voice is not 100%, and I beg your indulgence. I'd like to reserve 4 minutes of my time for rebuttal.
All right.
May it please the Court. The State's entire case against Mr. LOUIDOR is based on wholly circumstantial evidence to link him to a robbery of a 7-Eleven on South Orange Blossom Trail in Orlando that was committed by co-defendant Mr. Santos. There's no direct evidence that linked Mr. LOUIDOR to the robbery. No one identified Mr. LOUIDOR as the perpetrator of the robbery. There's no DNA evidence linking Mr. LOUIDOR to the mask that was used by Mr. Santos when he robbed the store. In fact, the DNA evidence was solely Mr. Santos' DNA and not Mr. LOUIDOR's.
Is the evidence that your client drove the robber to the store and then fled from the scene and evaded the police, is that circumstantial evidence of his act as a principal, or is that direct evidence?
Your Honor, I'd argue it's circumstantial evidence of any involvement. Mr. LOUIDOR knew nothing about the plan to rob the store. He knew nothing about it beforehand. He knew nothing about it at the time that he was providing a ride to Mr. Ambrose to the store. He knew nothing about it when they left the store. The first time that he realized something was wrong was when the police officer pulled in behind and put on his blue lights, and immediately Mr. LOUIDOR slowed his vehicle to stop. Mr. Santos said, "No, you can't do that, I just robbed that store." That's the first time that Mr. LOUIDOR knew of anything related to this plan.
But my question, I mean, those are arguments that I think are good for the jury, but the question that I have is whether or not it's direct evidence. You know, the Knight case says that the special standard of review only applies when every element of the crime is based on circumstantial evidence. So what I'm trying to understand is whether or not it's direct evidence that he drove him to the store, went inside some minutes before, and again, that could be wholly innocent, it could be wholly guilty. I mean, I think those are questions that the jury has to answer. And then fled the scene and evaded the police. Is that direct evidence or is that circumstantial evidence?
It's circumstantial evidence because it requires an inference stacking that distinguishes the circumstantial evidence from a direct evidence. Direct evidence is evidence that tends to prove itself without anything more. Circumstantial evidence requires an inference. The inference that the state tried to draw repeatedly and drew to the jury in opening and closing was that Mr. LOUIDOR drove Mr. Santos to the 7-Eleven knowing that Mr. Santos was going to rob the store and therefore was responsible as a principal. That is an inference that is not supported by evidence. It's not supported by anything more than mere speculation. Mere speculation is insufficient.
But there's a video, surveillance video of him, I think some 18 minutes before the robbery takes place, inside the store. And then there's direct evidence that he was the driver of, I guess you could call it the getaway car or the car that Mr. Santos went in. There's direct evidence because the police officers testified that they saw him behind the wheel, that he was driving, and that they extricated him from the driver's side of the car once it was stopped, and that it was driving in an erratic behavior. How is those observations and that testimony not direct evidence as opposed to circumstantial of the principle?
Because they all require emphasis, Your Honor. The fact that Mr. LOUIDOR was in the store some 18 minutes beforehand, the state would argue that he's in there to case the joint, right? That's the state's argument. He went into the store to case the joint, to scope it out, to make sure it was clear, then came back, sat in the car, told Santos, okay, go ahead, it's safe to go in the store, there's no one there. The problem with that is that that's purely speculation. That's purely speculation. There's no evidence to support that he was in there to case the joint anyway. There's no evidence that puts him in the store other than the videotape. There's no evidence that from any witness in the store at the time that said he was wandering around, he was checking out cameras, he was checking out the clerk, he was checking out the operation. There's none of that. It's just he was in the store 18 minutes beforehand. The state wants to say that that's evidence that he was casing the joint. That's not permissible. It's speculative. It's not direct evidence. The fact that he drove Mr. Santos to that store where he parked does not provide direct evidence that he knew of the plan to rob the store when he drove him there. That's the disconnect that the state has. The state's entire case, the state's case against Mr. Santos was pretty easy to make. He was identified, he's on the video, he had the money. That's pretty simple to do. What's harder for the state, and what the state wanted to do, was to wrap Mr. LOUIDOR into the case as a principal when they had no direct evidence to link him to it whatsoever. It was all speculation. It's all inference stacking. That's what separates it from direct from circumstantial. It's all circumstantial evidence. And I would suggest, Your Honor, that the Knight standard does apply in this case because it is a wholly circumstantial case. There is no direct evidence. And where all of the elements require inference stacking, they require some speculation, they require circumstantial evidence, that the state failed to prove that Mr. LOUIDOR acted as a principal. I would argue that the Lindsay case, Lindsay v. State, excuse me, and this is found at 14 Southern 3rd, 211, suspicions alone cannot satisfy the burden of proving guilt beyond a reasonable doubt. Even a deep suspicion the appellant committed the crime charged is not sufficient. Even a deep suspicion. In this case, it's solely circumstantial evidence. In a wholly circumstantial evidence case, the state is required to rebut any inference, any reasonable explanation, hypothesis of innocence. Mr. LOUIDOR was not involved. Mr. LOUIDOR knew nothing about it. Mr. LOUIDOR knew nothing about it until Mr. Santos told him, I just robbed that store, after they had left the premises, after they had left the store. He said, you can't stop. You can't stop because I just robbed the store. That's the first knowledge that could be imputed to Mr. LOUIDOR that a robbery had taken place. Perhaps an accessory after the fact, but that was not what was charged. He was not charged with that. He was charged as a principal in the commission of the robbery. There's circumstantial evidence only to tie him to the robbery. And in that case, the state has failed to rebut the reasonable hypothesis of innocence that he knew nothing about it, he didn't plan it, he didn't provide anything to help with it, he didn't encourage it, he didn't do anything to allow the state to say that there's any direct evidence that links Mr. LOUIDOR to this robbery. It simply wasn't the case.
You can see there was sufficient evidence on the fleeing. To get it to the jury?
To get to the jury, I suspect there may have been sufficient evidence because there's at least some evidence that any reasonable trier of fact could have found under that circumstance, right, enough to send it at least to a jury. I don't believe that the state proved that part of it only because of the nature of the events that took place in the car. The police officers testified in some detail about the jerky movements of the car, the erratic speeding up and slowing down of the car, consistent with some kind of struggle, some kind of disagreement between somebody in the driver's seat and someone in the passenger seat trying to evade the police. But there's at least some evidence that could get that to a jury. The problem with the robbery conviction, the problem with the assault conviction is that there is no direct evidence whatsoever that links him to that. And as a principal, there has to be more than just mere speculation. There has to be more than supposition. They can't just make it up and draw kind of all of these inferences together and stack them all together for the jury, and then the jury comes back and says, yeah, well, what the state said was true. That's not the way the case proceeded. That's not the way the evidence turned out. The evidence was purely and wholly circumstantial, and I would suggest tonight standard review is appropriate in this case, and I'm closing on my rebuttal time, but I would ask the court to reverse and remand with instructions. And I'll reserve the remainder of my time.
Thank you.
Thank you, Judge.
May it please the court, my name is Carmen Corrente with the Attorney General's Office representing the state. I'd like to start out by pointing out some additional facts that should be emphasized that hasn't been discussed yet. The most critical part of his defense was that he didn't know what was going on, and he had Mr. Santos testify on his behalf. Mr. Santos's testimony actually conflicted with his own. The words out of appellant's mouth when he was pulled out of the driver's seat was that he made me drive, I was robbed. If he was indeed robbed of his vehicle, there's no testimony or evidence to show that. There's no gun pointed at him. There was never any threat. And as a matter of fact, Mr. Santos himself, his own defense witness, said, I drove, not Mr. LOUIDOR. He said, I was the one driving the car. I took control of this car. So from the very beginning, from the appellant's own mouth, we have statement that does not match the rest of his defense. That is, his defense witness, his star witness that said, oh, Mr. LOUIDOR knew nothing about this crime. The story doesn't jive. You back it up, the police chased him, followed him all the way. Nothing was thrown out of the vehicle that they could see, yet Mr. Santos says he threw out a gun and the weed. There's no other mention of weed other than in that particular circumstance. Guy in the back seat, appellant's own brother, testified, we were going to the 7-Eleven, not we were going to go get weed. He didn't know anything about getting weed. They never got weed. So the state thinks that the evidence shows that they were waiting and casing that place until it was empty or with very few people in it. And the reason they parked where they were, Mr. Santos testified, it was no accident. They didn't park in front of the 7-Eleven. They didn't park in back of the 7-Eleven because there was a video camera there. They parked on the side where there was no one who could see them watching the place. Mr. LOUIDOR had to park there with purpose. He was driving. All of these facts point toward intent to participate. All of them do. It's a jury question. The state suggests that that the jury made a determination where they parked, casing the joint. The most damning piece of evidence is the fact that the mask that was used and the hat that was used was found on the driver's side of the vehicle. Why? Mr. Santos admittedly went in the store and used them. When he got back into the vehicle, he handed it back to the driver, who put it by the driver's seat. There's no question in the testimony that Santos was always a passenger, appellant was always a driver. Why would it be over there? if it wasn't handed back and didn't belong to it. So it was the vehicle was appellant's, the gun, only one gun found, we believe it matches the description. The gun was appellant's, the mask, the hat, the fleeing, and all of that establish enough. And in the case cited by appellant Theophily, one of the ones he relies upon, they make a statement or cite to a statement that says whether flight was evidence of the intent to participate was a question for the jury. This flight is replete from the parking and the leaving with enough evidence to support the jury's verdict. We would ask that you affirm if there are no further questions.
Thank you, counsel.
I wanted to ask you quickly about the firearm that was found in the vehicle. The firearm belonged to your client, correct?
That's correct. It was a properly licensed, properly stored, properly carried weapon that was in his glove box that he volunteered to the police when they stopped him, which he's required to do.
And the cashier at the convenience store.
Mr. Zia.
Mr. Zia came back, and did he identify the gun? Did he say that looks like the gun that was used?
No, Your Honor.
What did he say with regard to the firearm?
He said, I can't tell one from another. I couldn't tell one from another. I couldn't identify it. The only witness who purportedly made a reference to the weapon was Robert DeShane, who's called Homeless Bob.
Yeah.
Okay? Homeless Bob hangs around the 7-Eleven because he has nothing else to do. Homeless Bob wanted to be a hero before he had to figure out that he had to tell the state that he was afraid to make out the assault charge. But the Homeless Bob saw Mr. Santos enter the store, saw the weapon for a split second, retreated down an aisle away from the clerk's counter when Mr. Santos then proceeded to rob Mr. Zia in the store. I would suggest to Your Honor that with respect to the weapon, that Mr. Santos testified when asked to identify the weapon. He said, no, this isn't the gun I used. He used a pellet gun, and it was...
There was also some conflicting testimony, was there not, from, I mean, he indicated he tossed that out the window, but the officers didn't see anything tossed out the window, and they had their sight on the car, and the gentleman in the back seat testified, did he not, that nobody threw anything out the window?
2 points, Judge Berger. First, the testimony was that he did not throw it out the window, he simply discarded it. Police assumed that he threw it out the window, and that was the state's presumption as it proceeded against the case. What the state fails to do is to reconcile what Mr. DeShane told police was that he saw the vehicle leave to the far corner of the parking lot, stop for a period of some 30 to 45 seconds. Someone got out of the car. This was near one of those clothing bins that people use to collect clothing for charity. Someone got out of the car, someone got back in the car. Police never bothered to search, never bothered to follow up on that testimony, that statement from Homeless Bob, their hero witness. One point I'd like to make with respect to the hat and the mask. My brother suggested that Mr. Santos used the hat and the mask, left the car, did the robbery, came back in and handed them back to Mr. LOUIDOR, who then put them on the driver's side of the console. That is such wild speculation that that wasn't even proffered at trial. That assumption is so wild and so speculative, given that the DNA evidence, the only DNA evidence found on the mask, belonged to Mr. Santos. The state conceded that point through stipulation. There was no evidence whatsoever that the mask or the hat belonged to Mr. LOUIDOR. The fact that it was put on the driver's side and not the passenger side of the center console, I would ask Your Honors, in your own vehicles, If you get into your vehicle and you reach this way to finish locking your seatbelt, what's the closest side to there? It's actually the other compartment. That is irrelevant. That's a specious argument that I think the court should not pay mind to. I'd ask the court to reverse and remand with instructions to dismiss. Thank you.
Thank you. Thank you both.